So first of all, I would like to thank Aviv for taking the time and the effort to rearrange his agenda to be here with us today in Lisbon. Our guest is, as you all know, the US FTC's Director of the Bureau of Economics. Aviv is also, let me see if I say this properly, George A. Weiss and Lydia Bravo Weiss, professor at UPenn, with appointments to the Department of Economics and also to the Wharton School of Business, as well as Director of Competition and the Competition Policy Initiative. Our guest is also one of a handful of stellar empirical IO economists that keep pushing the frontier in terms of methods and answers to real-world questions, and I think you can never get enough of that. It's also always a scarce input to our work and so important for robust competition law enforcement. Aviv's outstanding contributions are attested by his long list of publications in top-tier journals such as the American Economic Review, the Econometrica, and many others. Aviv is a fellow of the Econometric Society. He was co-editor of both Econometrica and the RAND Journal of Economics, and editor of the Journal of Industrial Economics. This is not Aviv's first incursion into the corridors of competition law enforcement. In 2013, 2014, he was Deputy Assistant Attorney General for Economic Analysis in the US DOJ. As you know, more recently, in December 2022, Aviv was appointed as Chief Economist by US FTC Chair Lina Khan. And this, I believe, passed a very strong message to all of those, the voices that were questioning the role of economic analysis in the work of the US agencies. And this is because Aviv is widely known for being an advocate of strong, robust economic reasoning assisting enforcement decisions. So we are truly, truly delighted to have you with us, Aviv. Thank you very much. We made it happen after all. So let's start with an introductory question, because we all like to know what it is behind the scenes. You took office in January this year. So what can you tell us? How does it work? What is your job at the FTC?
Okay. Well, first let me start by thanking you for that very kind introduction. You know you get old when it takes 3 minutes to introduce you, but thank you very much. I also want to thank you for the invitation and for having me here. I'm very glad I could make it, and happy 20th anniversary. If we were in the US, one more year, and you'd be legally, you could drink legally. So maybe next year we could have, more wine, to follow the US exception. I should say before I start, just the usual disclaimer. What I'm about to say are my own views and do not necessarily represent the views of the Commission or individual commissioner. Okay, so going to your question, the role that I have is, in short, as the chief economist, but I am actually the director of the Bureau of Economics, which means that there's actually a non-trivial management part to it. Just to give you a sense, the Bureau of Economics currently has 120 FTEs. Okay, so 120 people just in the Bureau of Economics, not the whole FTC. Out of those, most by far are PhD economists. So we have almost 90 PhD economists. Now, if you've been following, you might say, wait a second, I thought the numbers were a little bit lower, and they were a year ago. Okay, so we actually increased our FTEs by 13 just this past year, and we're hoping to grow even further, subject to approval of the budget by Congress in 2024. We've been hiring a lot. We hired 10 new PhD economists this last year and 10 the year before that. And that's something that's a little bit missed. I mean, people like to think that the current administration is not favorable to economics. I want to sort of emphasize that's definitely not been my impression. I mean, I have a very good working relationship with our chair and all the commissioners, and the chair has been very supportive of all the stuff that I'm trying to do in BE, and maybe we'll touch on that a bit later. So besides the management of BE, a big part of what we do is actually advising the Commission. And what advising the Commission is make sure that the Commission gets the benefit of the best economic analysis that we can produce. Now, that doesn't always mean doing exactly what the economists say, but it always means that the economics is being heard and being part of the discussion. In terms of just our structure, just touch a little bit on what we do. The Bureau of Economics has 4 divisions. 2 of the divisions are antitrust divisions, and they work with the Bureau of Competition, which is the Bureau of Lawyers, on antitrust investigations and mergers. Okay, and that's about 2/3 of our economists. We have another division, the Division of Consumer Protection, that works with the Bureau of Consumer Protection, which are the lawyers that work on consumer protection matters. And then our 4th division, which is by far our smallest division, but that's because people kind of constantly, they're not based there, but they're constantly work with it, is on research. So one thing that's, again, folks that know the US system know this, part of our mission is to actually do research. And part of that is what we call 6B studies, what you might call market studies or industry studies. So these are studies that are sponsored and initiated by the FTC, and we gather data specifically for them. But then we have other kind of general missions that, we purchase data. So for example, healthcare is a very large area where we have a lot of interest. So we actually go and purchase data, and that's available for our economists to do research on. And this is research that they initiate, right? It's research that they want to do, and we encourage them to do that, to keep up to speed on the methods and the tools and to interact with the academic community. We encourage them to go to conferences and present this work, and also to publish it. And that's a big part of why we try to do that. And we do that, A, because our staff are interested in doing it, but it's actually a lot of value for us as an agency, both because it allows us to recruit really high quality people, but also make sure that they're kind of staying up to speed with the academic frontier. And over the years, we've learned a lot from that research that's informed our enforcement actions. So that's it in short. I can go on for a long time, but I think there's other things we want to cover.
So. But it's interesting to know that you're getting a big team or a bigger team, because you joined in a time, such an interesting time with so many things going on. And for sure, probably the most impactful or relevant are the draft FTC DOJ merger guidelines that were issued for public consultation in August 2023. And I must say, I think it must be the most commented policy document ever, right? So I recall you were in the CPR discussion with Christina asking for comments. This was in August, so now there were over 3,000. So God, that's quite impressive. So let's put our focus there and start with a strong statement. How would you see, or how would you label these guidelines? As an evolution or a revolution?
So the short answer is yes. Okay, so what do I mean by that? What's the serious? It has elements of both. Okay, there are definitely parts where what we take is, the stuff that's worked well, right? So I don't want to go back and say, look, our past guidelines are a disaster, they haven't worked. No, that's not the case. Okay, they've done the job, they were satisfying, they did, they were presented the state of the art as it was 13 years ago. But like anything, we need to update it. So we took what worked well, we updated things where we were finding issues, and I'll kind of get into more detail. And that's the part that's evolutionary. Okay? But there are parts that are new. The parts that were not there before, that introduces new elements. Okay? What are those elements? A lot of what we heard on the previous panel. As folks were talking, I'm probably not going to remember to insert that in my comments. I could say, well, that's what Antonio said, and that's what John said, and that's what, Patrick said. Examples of that are things that we're trying to deal with, and whether you want to call that revolutionary or not, I'll leave kind of the titles to others, but that's kind of the attempt of what we're trying to do. So they're both, I would say, at the same time.
Yes, and there's certainly elements of convergence between the US and the EU in many respects. So what, in your view, were the main goals of the agencies in revising these guidelines?
So I think the main goals are really to update the guidelines for the modern economy, right? To deal with the realities that I say all, but all the enforcers in the audience were facing, right? A lot of the stuff that we've been hearing throughout the day is to start kind of dealing with that and really ask, I would say two main questions. One is, where have we been failing and we need to do better to serve US consumers and workers, right? To serve better the economy. So that's one. And the other is, what are the new challenges? What are kind of new realities that we're facing and new challenges that we're already seeing and anticipating that we'll see more, and how do we deal with those? So let me give some high-level elements, and I'm sure we'll kind of dive more into this. So first, a key thing of what we're trying to do is to develop new pathways, right? The idea is that it's not kind of a standard unilateral, coordinated, horizontal, vertical, limited set, but instead saying there's many possible pathways to explore in any given merger. Okay, and as a result, we ended up with these 13 guidelines that try to sort of approach and look at different aspects. And again, we'll dive into those and see how they work. The other, and this is an important point, and I was thinking as I heard kind of the previous panel discuss this, a big thing of what we're trying to do is to remove labels. Okay? Labels, in my view, are not helpful. There is a tendency to try to label and say, this merger is a horizontal merger. This merger is a vertical merger, and therefore there might be a presumption that it's more efficient. Okay? I don't think that's going to be, maybe it was helpful in the past. Moving forward, that's not helpful because I think many mergers are going to have both elements of horizontal concerns or possible horizontal concerns, vertical concerns, conglomerate if you want to call it, platforms or ecosystems. It's going to have some of the above, all of the above, or maybe none of the above. Okay, so labeling things is not very helpful. I think what we need to focus is on effects. So there could be effects that are more horizontal in nature. There's some that are more vertical, although you'll see in a second I'm going to try to push back on that label, even for effects. But it's important to say when we evaluate mergers, there's a framework that we use, and that framework means looking at different pathways, but not we go one route if it's horizontal, another if it's vertical. There is a unified framework and a unified set of tools that we use throughout all these guidelines. So that's a second, I think, important element of what we do. And then finally, a key thing that we're trying to deal with is deal with uncertainty. We all know that we're trying to predict the effect of a merger. That's hard to do. That was hard to do even in widget type industry, right? But it's even harder in the digital economy. We talked a little bit in the previous panel about potential competition. The US law talks that a merger is illegal if it may or may be substantially lessen competition. Okay, we're not required to show things with certainty. It's with a probability. And judges often miss that. And maybe they require too high a degree of certainty. And that's one thing that we try to emphasize here is that what we're doing is essentially decision-making under uncertainty. Sometimes I call it a risk assessment framework. I don't love that particular phrase, but the idea is we're trying to make a decision under uncertainty and remind the courts through these guidelines that that's a key part of what we're trying to do.
Okay, and that takes a lot of sharpening of the tools, I guess. So what can you tell us about the details of the guidelines in terms of the tools that allow you to accomplish all that?
So as I said, 2 channels, new tools and improving existing tools. So in terms of new tools, and let me just list these, and we can dive deeper into each of these. So we added discussion of potential competition. Again, we heard that as a big discussion before. It was sort of present in 2010 in our previous guidelines, but not really major. A whole new section on platforms. A lot about dynamic competition and trends that appears in different places. Labor market, that was kind of in the background in 2010, but now we have an explicit discussion of labor markets. Theories of entrenchment of market power. These are all new elements that maybe existed in some short form in previous guidelines, but definitely not in the level of details that we have. In terms of sharpening tools, we sharpened market definition, and maybe I'll say a few more words about that. We're trying to sort of change the narrative somewhat about vertical, and we'll probably talk about that later. we have an appendix with a lot of the previous tools, and we concentrate and put them all together in appendix, not to minimize their impact, but actually to say these are tools that are used throughout these guidelines. Okay, they're not tools that just apply to one section. They apply everywhere, and that's why we put them in a separate guidelines. And then, as I mentioned, kind of continuous attempt to try to deal with uncertainty. Again, these are ideas that were present in 2010, but we're trying to elaborate on them. Let me just say one thing about market definition, because I think that's important, and you touched on it a little bit in the previous panel. Market definition is really a problem. It's a place where we face a lot of problems. Okay, now, for economists, and I think, Patrick was very clear about that in the previous panel, for economists, we like to say, hey, let's get past market definition, let's go back to effects. Okay, why are we obsessed with market definition? So we're obsessed with it in the US, I think, for two reasons. One is legally, we're required to show that there's a substantial lesson of competition in any line of commerce. So we legally have to define a market, okay? And I'll get back to that in a second. But the other is because litigators really like to go to a challenge with have what's called a presumption, right? Have concentration above certain threshold and feels like that actually, if they've won that, that's great. They basically have proven their case, and now it turns over to the defendants to rebut that. And when that works, that's great, right? When you actually can show, we all agree on the market and say it's a 3-2, right? It seems like, hey, that's great. There is sort of a feeling that, yeah, that is a merger that probably is harmful. The problem is that we try to do that in each and every case, and as a result, we end up having to define a market sometimes using 7 different adjectives, or it gets pretty complicated, and judges get confused. So what we're trying to do here is trying to get around that. So sometimes when it works, we will go directly with the market definition in more what's called a structural case. But the idea is we also open one of our pathways, what we call guideline 2, is one where we say, we're going to go fairly broad on the market just to satisfy the legal definition, okay? And then go and start talking about effects, okay? Or when we're talking, for example, about platforms and ecosystems, let's define the market in a broad sense. Let's not worry about market shares, because frankly, if we're talking about new products that don't even exist, it's almost impossible to get those market shares anyway. And let's go to start talking about the economics, about the effects, okay? Now, to do that, we also have to open several pathways in terms of how we define the market. And the idea is that we will use the hypothetical monopolist test when we can, but in modern markets, it's very hard to use. I mean, how do you do a SNP test, right? How do you talk about a 5% increase when there's no price, or there's a price of 0, okay? How do you do it on non-price elements? I mean, it becomes very tough to do, and rather than fighting that, we will say, let's go broad, let's give up on market shares and presumptions, and let's go to the economics. And that's actually a point that I think has been missed in a lot of the commentary that we got, is that these are the first guidelines that open that pathway, and I wouldn't be surprised, I mean, follow up on, I can't comment on ongoing cases and investigations, but, pay attention to what's going to happen in the next few months. You might see how we hope to use these tools.
Yes, that's a very interesting avenue. We will have to see, of course, how our courts will stand on this, but it's very important, particularly in the type of markets that we deal now. And that relates actually to the next question that I would like to pose to you, because this is also the first guidelines for the US, merger guidelines, that encompass both vertical and horizontal in one single document. And it's also a set of guidelines that were preceded by the vertical guidelines issued in 2020. They were very short-lived. They were withdrawn in 2021. And I recall when I was reading the comments at the 2020 guidelines, the vertical guidelines, one of the comments there was that it was lagging in terms of many elements, such as conglomerate effects, and it was not well suited, or at least clearly suited for the type of mergers in the modern markets that we are dealing then. So I guess that was a comment that can be accommodated in this version. Of course, if you look at the comments on the current guidelines, then you can see there's always opposing views. There's some that would prefer separate documents. I think Fiona called it the turducken, right? Which I was checking, it's a turkey, a chicken inside the duck, inside the turkey, cooked all together. But, but one cannot forget the criticisms that were made to the 2020 vertical guidelines. So what was the rationale for this all-encompassing document for the merger guidelines, Aviv?
So two things. And again, at a high level, I think we did two things here. First is we added a lot more on the non-horizontal guidelines aspects, right? So it's exactly dealing with, platforms, dealing with entrenchment theories. That's kind of where there's a lot more of the new material that comes in, and to deal exactly with the comments you discussed. But the other thing that we did is put these together in one document, and the comments here have been wide-ranging. Some really like it, some think no, you take something that's pretty clear, that's horizontal, and you're mixing it with something that's a little bit more messy. The reason we did this, and in my view, I think one of the biggest changes we've done in vertical, and this is to respond to a lot of the cases that you discussed in the previous panel. It's in order to win vertical cases, we get the impression, judges are just having a hard time mapping what we say on vertical cases to a lessening of competition. It goes back a little bit actually to Mike Walker's comment on the very first panel and about the use of economics. In my view, when you think about a case that involves vertical integration, the lessening of competition is not in the vertical part. And that's, I think, what we need to be clear. The lessening of competition is a horizontal effect, right? If you and I are competitors, right? So the way I kind of think of, at least the way to start thinking about a vertical case is the following. If you and I are competitors, and I got a control over an input that's important for you to compete, whether it's literally an input or maybe, a distribution channel or something else. But I got control over something that's important for you to compete. If we're significant enough competitors, I could use that in a variety of ways to, prevent you from competing as effectively as you can. And as a result, there would be a lessening of competition, right? So I get a chokehold over you, and there's a variety of ways in which I could use that. I could foreclose that input and prevent it from you. I could raise its cost, or I could just threaten to do that, and then maybe as a result get you to, collude and agree to do all kinds of things that you wouldn't otherwise, right? And maybe there's other things as well that you could do with it. If you start telling it that way, I don't think you need a PhD in economics or even to be an antitrust lawyer to say that doesn't sound good, right? If you're a significant rival and I now have control over you, a chokehold over you, right? I can use that in a variety of different ways. Okay, so what we need is to establish, right? And there was kind of three elements to that. It's I get control over that thing you need to compete, okay? Which means, I have either significant enough share or something. That thing is important to you. That's the second element. And third is that we are significant rivals, right? Again, that horizontal component, and that's established using the same tools that we use in horizontal mergers. Okay? That's kind of almost, we need to establish that before we go talk about all other kinds of effects, right? We can talk about efficiencies, we can talk about EDMs, but when we start talking about so-called vertical mergers, we should start talking about that. And the problem with going the way we've gone right now is we tend to go in too specific of a model that often doesn't match what businesses do, right? Because a lot of times the models that we have as economists say how business should act, but that's not necessarily how the executives think, right? So you can explain to them all you want about the benefits and elimination of double marginalization, but they don't think that way, right? So what happens is you go to a judge, you have an economist saying the theory, the judge doesn't really understand the theory, and then you have executives coming on board and say, no, Your Honor, that's not what we do, right? And where in the documents do you have anything that shows that we do this sort of vertical math? And the answer is usually nowhere, because they really don't think that way, okay? So who's the judge going to believe? This, economists that they didn't really understand, or these executives that maybe don't believe, but at least sort of make some kind of common sense? And that's the problem that we have. We have to go and explain in vertical mergers in plain English or plain Portuguese. What are the concerns? Okay, and they cannot be, we're going to talk through equations in words. We have to go to the basic incentive of, if we're competitors, I got a chokehold over you for something you really need. That doesn't sound very good. And that's a big part of what we're trying to do. And then showing the incentive and ability tools, or some of kind of, these other trends that exist, in our case law. They're just ways to potentially demonstrate this particular idea. So that's a big part of what we're trying to do there with vertical.
Indeed. Well, let's stay on vertical, because that relates to another question that I was planning for later, but let's do it now, because you're mentioning verticals. And the draft guidelines, the current ones, are much more fluid and blend on this regard than the 2020 version. However, in the 2020 vertical merger guidelines, you could see explicitly, you address explicitly the treatment of EDM and the burden of proof, which seem yet to be settled in court. There's other issues in which you take head on, like, for example, when there are reputational claims of reputational effects being a rebuttal argument, in which you say clearly, although courts have taken that into account sometimes, you say clearly we're giving little weight to that. So there's differences. What do you think in terms of the vertical guidelines are the main accomplishments that will allow you to get better outcomes in court?
So it's basically what I've just said, kind of the recasting of the issue, the saying, we first have to establish, very much like what we do in horizontal mergers, we have to establish what's the theory of harm, what are the facts, and then we go and consider the rebuttal arguments, whether they're efficiency or otherwise. And EDM will be evaluated as part of that. Okay? So I think that's kind of the hope here, is to really sort of first establish and convince courts, look, there actually is potentially a harm here, to establish that, and then we can start talking about what are the rebuttal arguments. So hopefully courts will be willing to kind of listen to this particular way, but to me seems like a very natural way. It's consistent with our case law. It's consistent, I think, with a basic way that we think about other, horizontal and other mergers. So hopefully that courts will go along with that.
It's interesting. And maybe you can read it as well as the fact Stephen Salop used to say always that it's not a special type of efficiency EDM, so you shouldn't treat it differently. So maybe you don't need to address it explicitly because it's just like any other efficiency. Well, that's a comment of my own. You don't need to comment on that. Let's move to another topic. Let's move to potential competition, which is mentioned, potential entrant is mentioned 35 times in the draft guidelines, 2 in the 1992 ones, and maybe 4 or 5 in the 2010 guidelines, right? So it's a huge increase of the focus in potential competition. It's the explicit focus of Guideline 4. There are also elements on other guidelines, like Guideline 7 on entrenchment. It's fair because these theories of harm are increasingly important to tackle mergers in modern markets. But mapping a theory of harm is one thing, backing it up is another, right? So there are challenges there. What approach do the guidelines postulate to support these theories of harm in front of the courts, for example, in terms of evidence gathering?
So first, I think what we're doing is kind of building on, John mentioned this in the previous panel, the meta within case, and in some sense, shoring up the theory of saying this is a valid, potential competition is a valid theory of harm. And I think, we're on solid ground there, but it's good to sort of have that, documented and shored up. I agree with you that the challenge there are the facts. Okay, what are the facts that you establish? What's the threshold for likely competition? And here the U.S. courts haven't really established that. Some have actually decided that, what you need is more likely than not. So think of it 50% plus a little bit, plus epsilon, as economists would say, but just a little bit more than 50%. Others have sort of claimed, no, that's too high of a threshold, should actually be lower. So that, I think, is the big question. And the question is, how do you prove that in a world where you're potentially talking about, products that don't exist, right? It was a big deal in the Sabre Fairlogics trial in the U.S., where, for disclosure, I actually served as the expert for the DOJ. And I think the judge sort of struggled, even though there was evidence of past competition between the parties, somehow that was not enough for the judge. He wanted something else. Maybe he wanted to see some of the stuff we typically do on other cases, but you just couldn't do that here, right? It's a potential competition. What is it that you prove? I mean, the theories are not that complicated, right? They're fairly basic theories of harm. It's a question of the proof. So we don't actually have right now, here's what we have, but we're hoping, that's something that will develop through actually challenges and cases.
Yeah, and I think you can see that a bit also in the ruling of the administrative law judge in Lamina Grail, when there's Fiona, she's presenting as an expert witness, and the judge concludes, well, I'm going to dismiss this because you still don't have effective diversion ratios for a product that was yet to be introduced in the market. So this can be challenging for competition agencies, I guess. Okay, so I did a lot of word counting on the guidelines. And another issue that comes popping up and, with a lot of light, a lot of spotlight, is labor markets. There's guideline 11 on monopsony power that stresses labor markets. When the guidelines mention harm, they now refer not only to price increases, quality reduction, but also lower wages. Wages get mentioned 16 times in the new guidelines, and I think that's a new addition. I think it was not mentioned before. Will this be a focus for the agencies from now on? And how will you respond to efficiency arguments regarding wage decreases being passed on to consumers? You have a footnote, 106, that states that this will not be accepted. But what is the rationale behind that?
So first, to your first question, will these be a focus? Absolutely, yes. Okay. We are, even in current investigation, always sort of looking at, is there a separate labor issue that we should bring? In terms of offsetting efficiencies, there's a lot of sort of said of like, well, if there's a let's say, reduction in wages in the labor market, doesn't that necessarily mean that there's going to be offsetting effect in the product market? So let me just sort of point out that in our most basic models, that's not the case. So models of monopsony behavior involve a reduction in output, and it's a reduction in output it's usually achieved through cutting, the product market output and also the labor that's used to. So that's kind of the Econ 101 class. So there's actually no offsetting to do. But there are other models, including models of bargaining and elsewhere, where you could imagine that there's harm in the labor market and maybe benefit in the product market to consumers. So what we're saying in these guidelines, and that's following a very long time tradition in antitrust, which is you usually or typically do not offset harm in one market with a benefit in another market. Okay, I mean, that's true, at least in the US, even when we're talking about geographic markets, right? You can't sort of say, hey, here's a merger that hurts, consumers in Boston, but it's really good for consumers in New York, so that's okay. I mean, sometimes at our discretion as prosecutors, we might decide not to bring that case. But if we do, we can just focus on the Boston market where there's harm. And, there's no defense of saying, hey, there's benefits in New York, therefore you should allow this merger. It's the same idea here, saying if there's harms in the labor market, you cannot offset them with out-of-market efficiencies. That's kind of the basic idea. And again, that's a well-established kind of legal principle.
Indeed, well-established. Now, Aviv, we're moving on to the last question. Yeah. So I'm going to ask you to be quite to the point because we need to wrap up. But it's an interesting one. And a much talked about one, right? So there's presumptions in the guidelines. You have the structural presumption on guideline 1. You have a foreclosure share presumption in guideline 6. Presumption that new entry yields pro-competitive effects, but there's many others. So my question is, as an advocate of robust economics-based antitrust decision, how do you see these presumptions and how do you see that they strike the right balance?
So just kind of for sake of time, let me just be quick and say, you need to separate those presumptions, although they're all under the bucket of presumptions. I think the treatment and how we deal with them is going to be a little bit different. The presumption in guideline 1, the static presumption on structure, let me focus on that. The others, I think we need to blend them in better, and that's probably how we're going to deal with them. But let me just focus on that structural presumption. And that basically says there's presumptions based on concentration. And what we need to be clear is these are rebuttable presumptions, right? What they're trying to pick up is, I think, a very intuitive idea that comes out of many of our models. And that is, which merger should you worry about more? A merger of, 10 to 9 or 3 to 2? Okay, probably the latter. Now, this is the idea that once we have that, that's something that raises concerns, and both in our investigation, but also if we decide to go to litigation, that can be rebutted. You could say, yes, maybe there's an association or correlation between structure and the economic impact, but in this particular merger, that's not relevant. Why? Either because you don't have the right, the market that you have, it's not that it's not right, the market shares are not indicative of harm because there's something else going on, right? And that's where you bring in the economics. So it's not that there's less economics, the question is, when do you bring it in, okay? And the reason we have kind of that structure to go along is partly just as an administrative process, right? I mean, we have literally hundreds of mergers that are evaluated each and every year, and we can't sit down and write a full model and do a full merger simulation for each and every one of them, okay? And even the ones that we end up going to court, sometimes we want to say, look, we've done all this other work, we are really convinced that there's going to be harm here, but we need to sort of go to the court and show them something that's simple, right? So one has to separate between what will convince us that the presumption is not rebutted and what we actually have to convince the court. So in my view, it's a way to sort of, simplify the analysis. And obviously, it goes hand with hand with doing the economics when we can.
So not if you have less economics, but when to bring it in. I thought that was quite a strong statement and very clear. I like that.
And I think, the current guidelines are not as clear about that. Hopefully, the revised version will be clearer about the fact that these are rebuttable presumptions.
Rebuttable presumptions. Aviv, it was my pleasure, really, and I think it was really insightful, all that you share with us. Thank you so much for this. Thank you. Thank you.